Public data powers the internet. From training AI models to building new apps, publicly available data sets have driven innovation around the world. But in India, that might be about to change. India's new data privacy law, the Digital Personal Data Protection Act 2023, comes with one small provision that could have massive consequences. Section 3C2 of the DPDPA states that publicly available personal data is exempt from the law, but only if it was made public by the person the data belongs to or by legal obligation. In this way, it aims to strike a delicate balance between protecting privacy and promoting innovation. Sounds like a win-win, right? But here's the problem. There's no way to verify the provenance of publicly available data at scale. So unless you can track down the source of every piece of personal data in a dataset and confirm that it was willingly made public, you can't use it. This is a nightmare for AI developers. AI systems rely on large, diverse, and messy datasets like Common Crawl, OpenML, or Kaggle to learn patterns, language, and behavior. But now, if any of that data includes personal information, and most of it does, developers need consent for every data point. Or worse, they can't use the dataset at all. And even if that consent existed in the past, they'll need renewed consent every time they want to use the data differently. Big tech companies might survive this, but small AI startups? They're not equipped to hunt down thousands of data originators or build data from scratch. Section 3C2 of the DPDPA could thus bring early-stage AI innovation in India to a complete standstill. And that's not just a tech issue, it's an economic one. With India positioning itself as a global AI hub, cutting off access to training data is like telling a chef to cook without ingredients. But it's not just AI. Anyone working with publicly available data, academics, researchers, journalists may be impacted. While the DPDPA exempts personal data processing, which is necessary for research, archiving, or statistical purposes from its ambit, neither the threshold for necessity nor the precise scope of these purposes is clear. So academics, researchers, and journalists may still face some uncertainty around their ability to use public data. In contrast, laws like the EU GDPR explicitly exempt personal data processing for journalistic and academic purposes from certain requirements. The DPDPA's focus on protecting privacy is understandable, but if it chokes access to publicly shared information in the process, it may inadvertently hurt the very society it wants to safeguard. That's why we're asking, should India rethink this provision? Should publicly available data remain accessible without impossible consent checks if it's already out in the open? We spoke to someone with extensive experience as a machine learning engineer and AI researcher to find out how Section 3 is likely to affect AI development.
Hi, I'm Sanket Kashyap. Currently, I work as the Chief Technology Officer at a stealth startup based in the wealth management space. Prior to this, I worked as a lead machine learning engineer at a Series C startup named Level AI for 6 years. Today, I want to discuss the Section 3C2 of India's Digital Personal Data Protection Act 2023, particularly the exemption given to publicly available personal data. The Act's definition uses overly simplistic examples, such as posting on a blogging site, which fails to capture the nuanced realities of digital data flow. Information online doesn't stay static. It constantly shifts in context, format, as well as audience. This issue becomes particularly complicated on anonymous platforms like Reddit or Blind, where users expect privacy through anonymity. The law doesn't clarify whether data shared under pseudonyms qualifies as publicly available. At the same time, linking data principals to the data source over here would be a huge challenge at scale. Additionally, online data frequently undergoes multiple layers of resharing and transformation. Information originally intended as private or semi-private can quickly become publicly accessible via screenshots, reposts, or third-party distributions. This rapid and often unpredictable spread of data, changing from text to images to videos, makes it nearly impossible for data principals to retain control or trace its origin.
To sum up, 3 factors make it difficult for AI developers to benefit from Section 3C2 as it stands. First, since data status as public or private is not static but constantly in flux, AI developers will find it difficult to determine whether any given piece of information was made publicly available by the data principal herself. Second, people often use pseudonyms while engaging online, but this comes with a downside. Pseudonyms mask the real identity of a person, which makes it tricky for AI developers to trace the origins of any publicly available information back to the data principal concerned. Finally, data about a person can be shared not just by her, but by several others and across different modalities. In such a scenario, it's difficult to determine whether the person who made it publicly available was the data principal herself. Ultimately, these challenges may throw a spanner in the works for AI development. Privacy matters, but so does access to knowledge. The DPDPA must be amended so that AI development is not hindered. Specifically, Section 3C2 of the Act must be amended to state that any publicly available data falls outside the scope of the law and can be used to power innovation. India's privacy law needs balance, not barriers.